4-year possession case, and he's also going to plead guilty to the violation, Your Honor.
All right, Mr. Van, now is that a complete and accurate statement of the plea agreement?
It is, Your Honor. The only addition that I don't know whether it was said or not is we would have no objection to a concurrent sentence with the new file and the probation file.
That's correct, Your Honor.
Okay. Mr. Raymond, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do, Your Honor.
And you are William Michael Raymond?
Yes, Your Honor.
Mr. Raymond, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty in file 25-22238-FH to count 1, possession of cocaine of less than 25 grams?
Yes, it is, Your Honor.
I'm sorry, do you understand the maximum possible penalty for that offense up to 8 years in prison and or a $25,000 fine?
Your Honor, the drug stuff is being dismissed. It's a 4-year.
Okay, do you understand, Mr. Raymond, that the maximum possible penalty for that offense is 4 years in prison or a $25,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty to in the 24-21808-FH filed to a contempt of court for failing to appear at a probation violation hearing?
Yes, Your Honor.
You understand the maximum possible penalty for that offense is up to 93 days in jail or $7,500 in fines?
Yes, Your Honor.
Is it also your intention to plead guilty to the underlying probation violation in that case, which was failing to report?
Yes, Your Honor.
And you understand that in that case, you had convictions for carrying a concealed weapon, which has a maximum possible penalty of 5 years in prison, and possession of cocaine less than 25 grams, which has a maximum possible punishment of up to 4 years in prison.
Yes, Your Honor.
And in the 24-21890-FH case, is it your intention, again, to plead guilty to a contempt of court for failing to appear?
Yes, Your Honor.
And also to the underlying probation violation for failing to report?
Yes, Your Honor.
And in that case, you were convicted of possession of cocaine less than 25 grams, the maximum possible punishment for that offense up to 4 years in prison. A second count of possession of cocaine less than 25 grams, again, maximum possible punishment up to 4 years in prison. And possession of a dangerous weapon, and the maximum possible punishment for that offense up to 5 years in prison. Do you understand all that?
Your Honor, can I speak to Ms. Underwood for a second, please?
One second.
Your Honor,
Yeah,
do you have a plea agreement sheet on this individual? I am completely lost because I came in late.
I do not. He is pleading in the 25 case to count one without the supplement.
Okay,
And he's got, in the other two cases, he's got a contempt in each case for failure to appear that he's pleading to, and probation violation for failing to report.
I'm sorry, Your Honor. Thank you.
so he's not pleading to anything in the 21890 case?
He's pleading to a contempt for failing to appear at a probation violation hearing, and the underlying probation violation for failing to report.
Okay. Okay,
All right,
thank you, Your Honor.
We have Ms. Underwood and Mr. Raymond back from the breakout session. Ms. Underwood, where do we stand?
We can continue, Your Honor.
I apologize, Your Honor. Thank you.
Okay, so Mr. Raymond, I previously advised you of the charges in both of your 24 files that you were convicted upon, and the maximum possible punishment for those convictions. Did you understand all of that?
Yes, I did, Your Honor.
And are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, I am, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record today. Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
That's correct, Your Honor.
Is that also your understanding, Mr. Raymond?
Yes, it is, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial and have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Raymond, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I do, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, I do, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any question about any of the rights that I've explained to you?
No, I do not, Your Honor.
And you understand that you're giving those rights up?
Yes, I do, Your Honor.
How do you wish to plead in file 25-22238-FH, the charge in honor about April 4, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of a controlled substance, cocaine, less than 25 grams?
I plead guilty, Your Honor.
And in file 24-21808-FH, how do you plead to the charge that you committed contempt of court by failing to appear for a probation violation hearing on March 12, 2025 at 8:15?
Guilty, Your Honor.
And how do you plead to the charge in that file that you violated the conditions of your probation by failing to report after your release from jail on January 31, 2025?
Guilty, Your Honor.
And in file 24-21890-FH, how do you plead to the charge that you committed contempt of court by failing to appear for a probation violation hearing on March 12, 2025 at 8:15 a.m.?
Guilty, Your Honor.
And in that file, how do you plead to the charge that you violated the conditions of your probation by failing to report after your release from jail on January 31, 2025?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to any of those charges?
No, they have not, Your Honor.
Do you understand that if I accept your plea today, you're giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed at court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, I understand, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Raymond to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Raymond, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, she has not, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I do, Your Honor.
Is it your own choice to plead guilty?
Yes, it is, Your Honor.
Ms. Underwood, do you want to establish a factual basis?
Yes, Your Honor. Thank you. Mr. Raymond, let me take you back to April 4th, 2025. You were in the city of Adrian, county of Lenawee, state of Michigan,
Yes, I was.
and you were a passenger in a car that was stopped, correct?
Yes, ma'am.
And you were being arrested on warrants, correct?
Yes, ma'am.
And you, at that time, told the police and did have cocaine in your cap. Is that
Yes, I
correct?
did. Yes, ma'am.
And you had no legal reason to possess that cocaine.
No, I did not.
I believe the facts are sufficient, Your Honor.
Mr. Urbano, are the people satisfied?
Yes, Your Honor.
All right, Mr. Raymond, with respect to the 2024 cases, you had been on probation in those cases after you pled guilty to the charges that we discussed back in December of 2024. Is that correct?
Yes, Your Honor.
And one of the conditions of your probation was that you report to your probation officer as instructed. Is that also correct?
Yes, Your Honor.
And you were instructed to report to your probation officer upon your release from jail back on January 31, 2025. Is that right?
Yes, Your Honor.
And you did not, in fact, report to your probation officer that day, did you?
No, I did not.
And as a result of that, we sent out an order directing you to appear at a show cause hearing regarding that probation violation to be in court on March 12, 2025 at 8:15. Is that correct?
Yes, I believe so, Your Honor.
And you did not appear in court on that date. Is that also correct?
That is correct.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonetto? Mr. Bayonetto, are you there? Mr. Bayonetto, has the court complied with MCR 6.302 B, C, and D?
It has, Your Honor. I apologize. We're a little short-staffed today. I got pulled
All right.
away for a second.
Ms. Underwood,
It has, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Raymond has had full knowledge of his rights and he's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 27th at 8:15 a.m.
Your Honor, may I be heard as to bond on this issue?
Go ahead.
Mr. Raymond has already done, I believe, a significant time in jail, Your Honor. I'm not sure it's going to guideline to much more. And sentencing would be 7 weeks away. I would ask if the court would consider releasing Mr. Raymond under obviously very strict bond and probationary conditions regarding drug testing and the like, Your Honor.
Mr. Bano, is anything that you want to say with respect to that request?
Yeah, sure. And I would object to a modification of bond at this time. Mr. Raymond is, I think, very clearly still in the throes of addiction. He has a history of failing to appear for cases when released. So I would suggest I would object to an amendment of the bond. I think it is appropriately placed, and so I would just ask that the court not amend it at this time.
Right, at this point, I agree with Mr. Bayanetto. Provided opportunities for Mr. Raymond to be released on supervision, both probation and bond conditions. And I think that
I have received travel applications for both of the.
I'm sorry, I couldn't hear Ms. Teskey.
she was. I'm sorry. I was saying that I agree with Mr. Bayanetto that the bond conditions, I think, are appropriately set given Mr. Raymond's circumstances, and so I would deny that request. Mr. Raymond, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay, Your Honor.
All right, you can let the officer with you know that you're done with court for today.
All right, thank you, Your Honor.
Your Honor, I have 2 MDOCs in the other courtroom that Judge Angelo really wants me to get back to.
All right.
Thank you. I'll be back.
Okay. Mr. Murphy, do you need to speak to Mr. Dillenbeck?
If I could, please, Your Honor.
And you're Mr. Smith at the jail, is that right?
Yes, sir. Yes, Your
Okay.
Honor.
Mr. Malero was here. He's just stepped out. As soon as he gets back here, Mr. Smith will hear your case.
Sounds good, sir.
Mr. Dillenbeck, I'm going to put you in a breakout session with Mr. Murphy.
All right. Thank you, sir.
Okay, Mr. Goldstein, are you there?
Yes, Your Honor. I'm in my car, so I had to pull over before I could respond.
Okay. Mr. Cadell, do you want to come forward to the podium, please? This is file 25-22244-FH People versus Deshaun Olajuwon Cadell. We are here today for an arraignment in this case, and we are proceeding today by partially by video conference and partially in person. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bannett.
Alex Bannett for the people.
David Goldstein appearing on behalf of the defendant.
And sir, you are Deshaun Olajuwon Cadell.
Yes, sir.
All right, Mr. Goldstein, does Mr. Cadell wish to have the information read?
No, Your Honor, we would waive its reading. My client stands mute, asks that a not guilty plea be entered.
All right, I will enter not guilty plea for Mr. Cadell, and we will set a pretrial conference case for go with June 18th at 8:15 a.m.
I'm sorry, Your Honor, June 18th, you
18th.
said? Yep.
Yes,
Okay,
18th.
thank you, Your Honor.
So Mr. Cadell, your
Yep,
next
got
date
it.
is June.
Thank you.
Your next date, Mr. Cadell, is June 18th at 8:15. You can come to the courthouse as you did today in person, or if you want to do it by video conference, you can do that as well, and the bailiff has our information. Okay, so you're all set for today.
Thank you, sir.
Thank you, Your Honor.
Thank you, Mr. Goldstein.
Thank you, Your Honor.
Thank you, too, sir. Okay, I have someone logged in as Stephanie's iPhone. Can you tell me your name?
Sure.
I'm sorry, your connection is not good and I was not able to understand that.
Cheryl Van Dyke.
Okay. Okay, Ms. Van Dyke, that hearing got adjourned to June 18th at 8:15 a.m. So that Mr. Van Dyke could get screened for a public defender.
Okay.
So you can go ahead and log out, and the next date again is June 18th at 8:15.
Thank you.
Okay, Mr. Murphy, are you ready to proceed with Mr. Dillenbeck?
Yes, Your Honor. Thank you.
Okay, this is file 24-22094-FH People versus Ryan James Dillenbeck. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. And I apologize, we've got two files here. So 24-22094 and 24-22095. Both set for pretrials today. Three?
I have it down for 3 files, Your Honor.
Yeah,
25197.
Correct. So also file 25-22197-FH. So, all right, now that we've got them all, we are here today for a pretrial conference. Can I have the attorneys place their appearance on the record, beginning with Mr. Bannett?
Alex Bannett for the people.
Matthew Murphy appearing on behalf of Mr. Dillenbeck.
And sir, you're Ryan James Dillenbeck.
Yes, Your Honor.
Okay, Mr. Murphy, where do we stand with Mr. Dillenbeck's cases today?
Your Honor, I was emailing with Mr. McClure about the plea offer in this matter. I think we've come to an understanding of what the offer is. Mr. Dillenbeck was asking if we could adjourn just briefly. We have a scheduled appointment Friday at 2 o'clock to discuss the plea offer at length and what we'll be looking at. So if the court would abide me just, a brief adjournment, whatever fits the court's schedule best, I think we'll have the case resolved by that next date.
Okay, Mr. Bayonetto, is there anything we need to address from the people's side today?
No, Your Honor.
All right, so I'll adjourn this to June 4th at 8:15 a.m.
Yes, Your Honor.
I would say, Mr. Murphy, at that point, two of the cases are going to be 6 months old since bind over, so I would set something for trial at the next one if there's no resolution.
Understood, Your Honor. Thank you.
All right, so Mr. Dillenbeck, your next date is June 4th at 8:15 a.m.
All right. Thank you, Your Honor.
Mr. Murphy, would you do a stipulation in order for the adjournment?
I will, Your Honor. Thank you.
Okay, Mr. Dillenbeck, you're all set then. You can go ahead and log out.
Thank you, Your Honor. Have a good day.
Thank you, Mr. Dillenbeck. I'll talk to you on Friday, okay?
All right. Have a good week.
Thanks.
Okay, Mr. Miller, are you ready to proceed with Mr. Smith?
I am, Your Honor.
This is file 25-22247-FH, People versus Dustin Wayne Smith. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
Tom Miller on behalf of Dustin Smith.
And sir, you are Dustin Wayne Smith.
Yes, Your Honor.
And Mr. Smith is participating by video conference from the Lenawee County Jail. Mr. Miller, does Mr. Smith wish to have the information read today?
At this time, we acknowledge or say the information waive its reading. Open court, we have any defects as the time and place of service. Mr. Smith would enter a plea of not guilty and ask that the matter be set for pretrial. Judge, a preliminary exam was conducted on this case. And he was bound over on one count. And so we're going to need at least 90 days. I mean, I would suggest a pretrial perhaps in 45 days, but we're going to need at least 90 days before we can proceed on whether or not to set this for trial.
All right, I will enter not guilty plea for Mr. Smith. We'll set a pretrial 5 days, which would be about 5th at 8:15 a.m.
Fine, Judge.
All right, is there anything else we need to address with the case today?
Not this time.
Not from the people, Your Honor. Thank you.
Okay, Mr. Smith, then you can let the officer that's with you know that you're done with court for today.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you.
Could we have Jennifer Allen in for the judge? Thank you.
Sorry, Mr. Dagger Margosian. Mr. Nelson is not logged in or here in the courtroom. Have you had any communication?
Your Honor, I spoke with Mr. Nelson yesterday and the day before about the case. I was expecting to be on Zoom. We're really just waiting on the preliminary exam transcript, and so I was going to ask for an adjournment anyway, but I have had communication with him, and that would be my request at this time, I guess.
Let me, we weren't on the record there, so it's file 25-22150-FH, People versus Milo Edwin Nelson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayonetto for the people.
Your Honor, Michael Dagger Margosian for Mr. Nelson.
And Mr. Dagger Margosian, you would just explain the situation to me off the record. I apologize. Can you do that again for the record?
Your Honor, I have spoken with Mr. Nelson. We held a preliminary exam in district court on this case. He was bound over. I'm waiting for, we've put the request for the exam transcript in, and so we're waiting on that. My request at this time would be to adjourn the pretrial for, I don't know, 60 to 90 days or so we can get the exam transcript.
Okay, Mr. Bayonetto, is there anything we need to address from the people's side?
Your Honor, I would ask that the court issue a bench warrant in the case. I wouldn't object to a 48-hour hold. Maybe there was just a miscommunication if the defendant thought the case was going to be adjourned. But he does have a significant criminal history that spans multiple states. I was going to try to sift through his files in our system, but I don't know whether or not he has a history of failure to appear, Your Honor, but that would be our request at this time. It looks like there was a failure to appear in this case on January 14th when it was still in district court.
I don't know if the court wants me to respond, but
Mr. Dagger Margosian, you said that you spoke to Mr. Nelson yesterday.
correct.
Is that all right? Okay, what I'm going to do, I'm based on Mr. Dagger Margosian's representation to the court that he had communication with Mr. Nelson yesterday. I'm not going to issue a bench warrant today. I would obviously treat this as a failure to appear if we have another instance of Mr. Nelson failing to appear. And so I would not be obligated at that point to give him a grace period, and I probably would not do that if he fails to appear here again. So I will adjourn this. Just looking at the file, looks like the prelim transcript was ordered back in February and its due date is the end of the month. So what I will do is adjourn this to June 25th at 8:15. And Mr. Dagger Margosian, would you prepare that stipulation in order, please?
Yes, Your Honor, and I'll communicate with Mr. Nelson the new date.
Okay.
Your Honor, that was June 25th, right?
Correct.
Okay, thank you.
Okay, I think we're all set on that one.
Again.
And Mr. Murphy, we've called for Ms. Allen at the jail and we'll proceed as soon as we have her.
Yeah, thank you, Your Honor.
Let's see, Mr. Murphy, we had Cassie Coley got picked up on a bench warrant for failing to appear at her pretrial. Do you want to do that one?
Yeah, I mean, we can address that, Your Honor.
Okay. We'll call for her right now as well.
Could we have Cassie, Chloe, and then the room for the judge, please? Yes, Kate. All right, thank you.
Judge, have you addressed Jennifer Allen yet or no?
No, we are waiting for her to get put into a booth at the jail.
Okay, and then Trisha Steele, have you addressed her?
We did do her case. She got adjourned to June 4th.
Okay. Anthony Vargas, he's not till 10:30, so I don't know if you've gotten to that yet.
Correct. We've not done that one yet.
All right, and then I'm gonna ask you about a couple on the second page. Dwayne Dunning, Xavier Ghana, I know Milo Nelson got adjourned. Leopoldo Perez.
We have not seen Mr. Perez yet.
Your Honor, I'm gonna log off Zoom and come up in person. That way I'm ready for the motion hearing whenever the court is.
Okay. Mr. Dunning got adjourned. Mr. Ghana pled not guilty, and we set a pre-trial.
Okay, I think besides that, I have everything else.
Okay.
Thank you. Called Ann Arbor Comprehensive Treatment regarding the offender being on methadone.
Okay, Mr. Murphy, Mr. Vargas is logged in. Are you ready to proceed with this case?
Your Honor, I wanted to be in person for the motion hearing, but I guess I could proceed just via Zoom for that, as long as everyone can hear me fine, which I think everyone can if we wanted to do that.
Yeah, I guess I'd prefer to do that then.
Yeah, it seems like we're waiting on dead time right now, and we can address Mr. Vargas's case.
All right. So this is file 24-21940-FH, People of State of Michigan versus Anthony Ryan Vargas. We are here today for a hearing on defendant's motion to quash the information and dismiss. We are proceeding today partially in person and partially by video conference. First, let me ask the attorney to place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy, appearing on behalf of Mr. Vargas.
And sir, you are Anthony Ryan Vargas?
Yes, Your Honor.
Right. Mr. Murphy, this defendant's motion, you can proceed with argument.
Yes, Your Honor, thank you. Now, I do have quite a bit to say about this case. I'll start by addressing something I wasn't really contained directly in the motion. It's addressing, as we well know, the Michigan Supreme Court has said in People versus Anderson, I think it was 2018, that a reviewing magistrate or district court is required to consider the credibility of witnesses at a preliminary examination. They're to consider that credibility along with other evidence presented to it. Now, we presented the court with the transcript from this preliminary examination. I don't know how else to say it, but there's differences, big difference between what the officers testified to and what the body cam showed, I believe. Now, the officers testified multiple times. They said they announced themselves as police entering the home. I reviewed those body cams for dozens of hours. I've tried as painstakingly as I could to line up and put that in the motion, the timestamps and what was occurring and what was said and what you could hear on the body cams. And again, as I placed in there, I've hoped this court's reviewed those body cams I provided with the court. The word police was never used by the officers. They never announced themselves when they entered the home as police. As you could see, Officer Eichmann enters the home and just says, "Anthony, we're going to find you." Now, again, I believe I've contained in my motion. I've tried to find the case law about, again, what the police are supposed to say. It was pretty clear about knock and announcing, cases involving failure to knock, failure to appropriately knock when they enter, not given enough time. In regards to the announcing portion, it was difficult to find cases, which is why I refer back to a 1995 case, or a U.S. Supreme Court case, and Justice Scalia's, evaluation and explanation of the knock and announce principle. And that a police officer, again, that goes hundreds of years back, it explained that policy, that a police officer is to announce their presence when entering a home. And that announcement was to include that the police officer is there, that it's the police, and the reason for them to be there. This announcement is to notify. It's not for officer safety. Well, obviously it has that leg to it. That's not purely what it's for. In fact, as you can see in my brief, it wasn't discussed about officer safety. It was discussed about notifying the individuals in the home about the presence of the police and the fact that they are now engaging in a lawful act, that they are there for a lawful reason. That did not occur here, Your Honor. They entered the home. Officer Eichmann entered the home. And again, as I claimed in the motion, I would attack the idea that it was given with consent, that he entered with consent. Consent has, the burden's on the people to prove consent was given. I don't believe that Ms. Morgan gave consent. As you could see, she was trying to say that she didn't own the home. And it was pretty clear that she was questioning why Officer Eichmann was insisting on having to go in, and it was clear from the beginning. Officer Eichmann said, if you don't let us in, we're going to boot the door, thereby saying she had no other option but to let them in, or else there was going to be property damage. But again, she asserted that she didn't own the home, that she shouldn't have permission to let them in. Now, again, this is difficult to basically break this down and going forward from there. If consent was given, again, Miss Morgan can't give consent for the officers to not notify Mr. Vargas that they're there or why they're there. Again, the announcement part includes them to announce the reason why they're there. And I don't think Miss Morgan can waive or somehow consent to them not informing Mr. Vargas. As you saw in the body cam, they never said we have a warrant for you. They never said we're investigating an allegation of domestic violence. Now, Officer Eichmann had testified that Miss Morgan wasn't clear, but he developed probable cause that an assault had occurred and that Mr. Vargas was the one who perpetrated it. On the body cams, that's not what comes across. Actually, I would say that on the body cams, Officer Eichmann is the one who's not clear. And Miss Morgan is pretty clear that she's asking for more information and pretty clear that she didn't call the police. And that's one of the things that the court needs to remember here is that Mr. Vargas didn't call the police. Miss Morgan didn't call the police. It was her brother who called the police. So when the police entered the home, when Officer Eichmann entered the home, Mr. Vargas had no idea that the police were there. He just hears someone calling, Anthony, we're going to find you. And when they do confront him again, they do not say we have a warrant. They don't say that we're here to arrest you on a warrant. They don't say we're here investigating a domestic violence allegation. No, Your Honor, again, our assertion is that entering the home in that way, trying to arrest a person in that way without notifying them when they entered the home, without notifying the individual of the home that the police are there, is a violation of the Fourth Amendment, is a violation of a person's right against an unreasonable search and seizure, against unreasonable seizure. And that's where we're saying that it's unconstitutional, and that's where we're saying that the motion to dismiss is based upon. I'm sorry, I do want to clarify, obviously, this motion to quash is based upon counts 1 and 2, and addressing counts 1 and 2. There's a domestic violence charge. I believe that's count 3. That's not the subject of this motion because it's a misdemeanor, and obviously that wasn't subject to the bind over. So again, I just wanted to clarify for the record, this motion to quash is involving the 2 felony resisting and opposing officer charges. But again, Your Honor, I'm sorry, I do know I'm going on for a bit of time, but I do have a lot to say about this case. Again, the district court had viewed the body cams and made no notation, no comment about any type of credibility issue at that point. I would say these officers, again, they intentionally lied and said they did say they announced themselves as police. And that, Your Honor, I think is a telling factor as well. The police knew and know, and the prosecutor knows that they should announce themselves as police when they enter the home. That's why the question was asked, and they know it's unreasonable to not do it. That's why the lie said they did, Your Honor. So again, we believe that the entrance into the home and the arrest of Mr. Vargas in this fashion was unconstitutional, and therefore, if there was any resisting, which I believe came to my motion, I don't believe that even if it was perfectly fine what the officers did, and it was completely constitutional, I don't believe Mr. Vargas even did anything that was resisting. The district court noted, it didn't note that it observed anything on the body cams that was considered resisting. The district court noted that Mr. Vargas allegedly tensed up per testimony of the officers, which again, I'll call into question the credibility of the officer's testimony in regards to almost anything. And so tensing up, Your Honor, that I would say does not rise to the level of resisting an officer if the person tenses up because they're being grabbed. So, Your Honor, we'd ask the court to grant the motion to quash on counts 1 and 2, and obviously domestic violence, that's not subject to this motion.
All right, Mr. Van Edel.
Thank you, Your Honor. I understand Mr. Murphy's argument, and if this were a case where Mr. Vargas did not respond to police orders, when they had entered, when he was behind a closed door, and they had not identified themselves, I think that argument would carry a little bit more merit. However, the facts of the case don't line up to that. Your Honor, the resisting arrest comes into play when Officer Eichmann informs Mr. Vargas that he's under arrest. At that point, that's when the struggle ensued, and that's the conduct at issue that led to the resisting arrest charges being filed. Your Honor, there's a period of time where Mr. Vargas comes out of the bedroom, speaks with the officers who were in full uniform, acknowledges that they are police officers, and then tries to walk out the front door. That's when they tell him, no, you can't. And Officer Eichmann informs him he is under arrest. This is not a situation where they didn't identify themselves. Mr. Vargas didn't listen to what these people in his home were saying, and charges were filed based on that. I apologize, Your Honor, I didn't print my brief out, but at preliminary examination, we just have to show that there is probable cause to believe that this defendant committed a felony. I think the body cam is clear. Officer Eichmann informs Mr. Vargas he's under arrest. Mr. Vargas, as Officer Eichmann testified, tensed up. There was a significant struggle that led to officers having to take Mr. Vargas to the ground. That's the conduct that's at issue here today. Whether or not tensing up qualifies as resisting arrest, or any of Mr. Vargas's conduct after being informed he was under arrest rises to the level of resisting arrest, is a question of fact for the jury. That's not a question that this court should answer at this point. Testimony needs to be established, evidence needs to be presented, and a jury needs to determine whether or not this conduct actually is resisting arrest. Mr. Murphy, I think, has acknowledged that there's no case law that would support a dismissal based on the officer's failure to identify themselves when they are in the home. But again, Your Honor, I don't think that even comes into play, given the fact that once Mr. Vargas is informed that he's under arrest, there is a struggle. And again, I would submit that that is the conduct that constitutes the resisting, not what led up to it.
I guess where I'm stuck, Mr. Bando, if they're not lawfully inside the home, then it's not a lawful arrest, isn't that?
Well, Your Honor, I would submit that they were in the home lawfully.
Okay, but I just play along hypothetically. I know that your position is that you think that they lawfully entered the home. But if they did not lawfully enter the home, then it would not have been a lawful arrest. Is that accurate?
Just a point of clarification, Your Honor. Are you saying they were not lawfully in the home to arrest for the domestic violence, or the warrant that was outstanding?
For whatever purpose. For whatever purpose. So I mean, my view of this is that I have to make an initial finding as to whether or not they were lawfully in the home. If I were to conclude that they were not lawfully in the home, would it not necessarily follow that the arrest was not lawful?
Your Honor, I'm not familiar with the case law as it relates to that. I can't give the court an informed answer.
Okay. All right, so I stopped you. You wanted to say something about whether or not they were lawfully in the home.
And yes, Your Honor, and I did cite those in my brief. MCL 764.21 does allow an officer to, in fact, break open an inner or outer door when making an arrest with a warrant. So I understand Mr. Murphy's position that Officer Eichmann informed the victim in the domestic violence case that, you either let us in or I can boot the door in, but that doesn't make what he said unlawful. They are given that right pursuant to statute. Ms. Morgan did eventually let them in, so I would submit that they were in there lawfully, and I would just rely on the contents of my brief and ask that the court deny the motion at this time.
Mr. Murphy, you care for any rebuttal?
Yes, Your Honor. Your Honor, the case law is the U.S. Constitution, the Michigan Constitution. They cannot, if they illegally enter the home, nothing they do in there can be, they can't engage in a lawful arrest. They can't engage in lawful behavior if they illegally got into the home. Your Honor, the cusp of this motion, there's multiple issues here. If consent was or was not given, again, that statute, that's exactly what the case law all cites for that statute. That statute says that they can break, they can announce and break, they can enter, but it doesn't say they can sneak in there. That's the issue that we have here, Your Honor, is that if this is the situation that it's okay for officers to do this, then an officer can find a person who has a key to a home, whether it be, if it's a private home, a spouse, or if it's a rental, the landowner or the landlord or maintenance person. They can get entrance into the home, and if they don't have to say that they're there, if they don't have to announce that the person is the subject of their reason for being there, that they're there, they can just go into the home at 3 o'clock in the morning, sneak up to the person when they're sleeping, and throw a bag over their head and arrest them. And that's not the way things occur in a free society. That's what happens in a police state where police act like they can do whatever they want to. And that's the cusp here, Your Honor, is that even if consent wasn't given, if Ms. Morgan wasn't there, the question then would become how are the officers entering the home? Well, they're entering the home under the guise of serving that warrant. Is it okay then to knock in the door of a home without saying you're the police? And obviously our argument, and I believe it's pretty clear that the police are not allowed to do that. They have to say that they're the police, and they have to say why they're there. They did not say why they were there until, actually they never did. They said you're under arrest right as Mr. Vargas was trying to move away from them. And he says, I'm trying to leave now, get out the door. And they say you're under arrest and grab him. And right there, you can see from the body cam, Officer Eichmann grabs his left hand, and Officer Nieto, I apologize if I'm not pronouncing the names correctly, grabs his right hand. And the question is, to what extent, once both the officers are holding him, does he actually have any control over himself at that point at all, or are they guiding him to the floor? But again, Your Honor, I argue that the entrance of the home was unconstitutional. Therefore, the arrest on the warrant, or the warrantless arrest, or whatever they want to say they did in there, was all illegal, Your Honor. And we're asking the court to grant the motion. Thank you.
Well, let me push back on you a little bit, Mr. Murphy. Doesn't the statute only require them to announce they're present if they're breaking an inner or outer door? I mean, that's all part of the same sentence, right?
I'm sorry, Your Honor. Let me just pull up the statute real quick.
I guess to say more clearly, it allows them to break open an inner or outer door in the building where they believe the person is present if they announce their purpose, after they announce their purpose. But in this case, they didn't break any doors, did they?
Well, Your Honor, I'm sorry. What was the statute number?
It's 764.21.
Because, Your Honor, in regards to that statute, the cusp here is, again, the announcing themselves. And that's what the case law referencing that statute as well in Michigan. I went back trying to find cases in regards to this statute, and it was never about a violation of them not announcing themselves. They always announced themselves. They always said why they were there, or that they were the police. The statute says that they're allowed to go into a home when they know a person's there. They're allowed to break and enter. Basically, obviously, saying that they're not committing a crime by entering the doorway. And as we all know, there's no requirement for them to actually break. So this is saying they're allowed to go into a home and arrest a person in there if they have a warrant, or if there's a warrantless arrest is authorized. But again, it still says that they have to announce themselves. So I think, looking at the cases,
where does it say that they have to announce if they've gained lawful entry to the home in some other fashion?
It says after announcing his or her purpose.
Yeah, and what does it? But it says before that you're not reading the whole sentence. The entire sentence says that they're allowed to break an outer or inner door after announcing their purpose. It doesn't say anything about if they've gained lawful entry to the home in some other fashion, does it?
Well, I took that to mean that was they can enter the home. So I'm sorry. I'm going to read the statute in its entirety. A private person when making an arrest for a felony committed in his or her presence, or a peace officer or federal law enforcement officer when making an arrest with a warrant, or when making a felony arrest without a warrant as authorized by law, may break open an inner or outer door of a building in which the person to be arrested is located or is reasonably believed to be located if, after announcing his or her purpose, he or she is refused admittance. So I took that to mean that obviously the person who's subject to the arrest warrant or to whatever is in the home, and the officer has announced to that person, I'm the police, I'm trying to get into the home either to serve a warrant, to search, or to arrest you, or I believe you just committed a felony. I believe, again, they announced to the person that the police are here wanting to enter the home, and the person has either not responded or refused them admittance, which is why a knock and announce, it requires some period of time after knocking for them before they can enter the home. You can, of course, get a warrant where there's a no-knock warrant where there is no time, but I believe you still have to, when you enter the home with a no-knock warrant, say it's the police. Otherwise, it would just be, again, like I said, you could go into the home whenever and sneak up and throw a bag over the person's head. What I read this as is that, and that's why I reading through the cases, they all seem to be pretty clear that the police, the person, the subject of the warrant or the subject of the search or was in the home was already aware that they were the police. Other instances involved people fleeing from the officers. And then obviously the question was, well, if the person's fleeing from the officer, do they have to stop and knock and announce and do that when they're entering the home, or can they just enter straight into the home? That case, obviously the person knows the officer. So that's why I took it to be, Your Honor, is that they can go into the home after the person knows that, again, after announcing that they're there and the purpose for being there.
Mr. Vargas is charged in this case with 1 count of assaulting, resisting, obstructing a police officer, and 1 count of assaulting, resisting, obstructing a police officer causing injury. Those 2 counts are the subject of this motion. He's also charged with a domestic violence, which is not the subject of this motion. Mr. Vargas has challenged the bind over after preliminary examination based on the manner in which the police officers entered his house to make the arrest, and also with respect to whether or not there was sufficient evidence to establish that he obstructed or opposed or failed to follow a command of the police officers during the arrest. In looking at whether, so I think that the first issue that the court has to resolve in making a decision on this motion is whether or not the officers were lawfully in Mr. Vargas's home at the time they made the arrest. Because if they were not lawfully in the home, then the arrest was not lawful, and therefore the commands given in the process of making the arrest were not lawful, and therefore an element of resisting, obstructing cannot be established. In order to examine whether the officers were lawfully in the home, the first issue that arises in this case is whether Ms. Morgan's consent was sufficient to permit the officers entry into the home. I have reviewed the body cam footage, and it was clear in that footage that Ms. Morgan went to the closed door and opened it for Officer Eichmann to walk in. And so the issue here, as I see it, is whether Ms. Morgan had whether her consent was sufficient to permit the entry, and therefore whether she had authority to consent to the police officer's entrance into Mr. Vargas's home. Police are able to rely on consent given by a person with the apparent authority to give consent, so long as that reliance is not unreasonable or circumstances do not call for further inquiry before reliance is reasonable. And that comes from Illinois versus Rodriguez at 497 U.S. 177, 1990. In this case, the only evidence regarding Ms. Morgan's authority to consent to entry into Ms. Vargas's home in the record that was before the district court at the preliminary examination was Ms. Morgan's statement to Officer Eichmann that the house is not in her name. That was the only thing that I could find in any of the body cam footage or any of the preliminary examination transcript testimony that addressed the issue of Ms. Morgan's consent to allow entry into the home. Ms. Morgan's statement that the house is not in her name presents circumstances that call for further inquiry before determining that she had authority to consent to the entry. No further inquiry was made in this case. Again, that statement by Ms. Morgan was the only statement that in any way addressed this issue. Therefore, it does not appear reasonable in light of those circumstances to rely on her consent to enter the home in the absence of some further investigation by the law enforcement officers. And as I've said, that did not happen here. So on the record before the court, I do not believe they had appropriate consent to enter into Mr. Vargas's home. So the next question is whether or not MCL 764.21 provides an appropriate basis for them to lawfully enter the home. That statute permits a peace officer when making an arrest with a warrant to break and open an inner or outer door of a building in which a person to be arrested is located or reasonably believed to be located if, after announcing his or her purpose, he or she is refused admittance. Again, on the record before the court, in the preliminary examination, that did not happen here. In this case, the video evidence is clear that Officer Eichmann did not announce his purpose before entering the home. Based on the record of the preliminary examination, therefore, it does not appear that to me that the officer's entry into the home was lawful. Therefore, I don't believe that the arrest and the commands given during the arrest were lawful. And consequently, the people, based on this record, are unable to establish a necessary element of resisting, obstructing, or opposing a police officer, specifically that Mr. Vargas disobeyed a lawful command of the police officers. And therefore, I believe it's appropriate to grant the motion and quash the bind over with respect to counts 1 and 2. And so that will be the order of the court.
Your Honor, I'll prepare an order presented to the court to that effect.
All right, I will sign that once it has been submitted.
And Your Honor, I'm sorry, just for clarification for myself, does that mean this file is going to go back down to district court then to address the remaining count? Or is it going to stay up in your court?
The only remaining count would be a misdemeanor at that point, and I think under the court rule that the remand is then appropriate. I can't cite the number of the rule right now. There's a rule that says when the last remaining felony's been dismissed, that it gets remanded back to district court.
Yes, Your Honor. Thank you for clarifying that. Thank you.
All right, so we're all set on that one for today. So Mr. Vargas, you can go ahead and log out.
Mr.
All right,
Vargas,
thank you
give me
very
a
much,
call
Your
later
Honor.
today if you have any questions, okay? I'll reach out to you soon though, all right?
All right. Thank you, Mr. Murphy.
Thank you.
Can you call the jail and see what's going on with Jennifer now? Okay, let's see, I'm sorry.
Hello?
Yeah, hello, can you hear me?
Yep, we can. Can you hear us?
And yes, I can. And this is Ms.
Okay.
Howe, correct?
Yes.
Go ahead.
Yeah.
Okay, thank you. Okay, this is file 24-22073-FH People versus Amberlynn Louise Howell. We are here today for a motion hearing. In this case, we are proceeding today by video conference. First, let me ask Ms. Brugman to place your appearance on the record.
Brugman on behalf of the people.
And Miss, you are Amberlynn Louise Howell.
Yes.
Okay, Ms. Howell, this is your motion to, I'm sorry, motion for modification of court-ordered obligations and restitution. You can proceed with any arguments you'd like to make on that motion at this point.
Yes, I was hoping to get my restitution suspended until I'm able to make parole. Seeing as I have 4 cases that I've resolved since being here, they're taking everything over 50, so I have had money put in, and even like my porter pay, everything goes to paying that off. I have 2 counties that I owe less than $200. One is to you guys and the other one's Oakland County. So I was hoping to get this suspended until I'm able to parole, and that way I'm only paying half, or they're only taking half of my money, and I'm hoping to pay the other check off in my remaining 21 months. I didn't realize that I was supposed to include information or evidence in my favor as far as my hardship. So I called my ex-husband last night and explained to him about this motion, and I did send in my judgment of sentences. So on February 3rd, I was sentenced, and I had to get that sentence amended because she wrongfully charged me consecutively. So I got all my new judgment of sentences for every county, and I mailed those home. So I have all my docket or my case numbers to pay those off. So I asked my ex-husband to start putting stuff together if I need to prove that he's been paying for, like, helping take care of my mom because she had congestive heart failure, had surgery, and she has to go to the doctors at least 2-3 times a week. He's going through his own health issues with blood cancer. So just kind of trying to prove the hardship, and being in here, I'm not able to take care of myself and then afford to eat and pay my obligations. So I'm not quite sure where to go from here. I'm just hoping you guys could work with me and on this motion. Yeah. It's kind of a lot.
Ms. Brugman, do you care to respond?
No, Your Honor, I would leave it. I mean, really, it's in the court's discretion on how to proceed. I would rely on my answer, just as far as the presumption of non-indigency. But otherwise, I'd leave it in the court's discretion on what they wish to do here.
Right. I think what I'll do is take this one under advisement. I'll issue a written opinion and order. So Ms. Howell, you'll get in the mail a copy of that explains what the decision is and the reasons for it.
Okay. Thank you.
So you're all set for today then?
All right, you have a good day.
Thank you.
Okay.
I think the last two cases we have are Jennifer Allen and Elizabeth Russell, is that correct? Or did we do Ms. Russell's case?
So have Odo Perez.
Which I believe.
Oh, that's a
is
probation violation, yeah. And you did Raymond. Sorry, you said Allen and who else?
Allen and Shabazz Russell. I don't know.
We did him.
Okay.
He got adjourned. I can't tell you the date off the top of my head.
Okay, that's fine. So it's just Ms. Allen that we're waiting on?
Yes. Okay.
Karen, do you actually need me on Jennifer Allen? It's just probation violation. Sounds right.
think we should probably, she's got a 25 case that we should probably treat as a pretrial as well.
That's fine.
Just 'cause I don't think there's any other dates set on it.
No problem. I'm just gonna step out there. Let's go. So I'm gonna go back downstairs and hop on some more reading. Okay.
Okay, you're Ms. Allen?
Yes.
Mr. Murphy, do you need to speak to Ms. Allen?
Yeah, I need to speak to her.
Okay, 1 second.
Thank you, Your Honor.
Do you want to call for Mr. Cassidy? Okay, Rhonda, have you heard from Leopoldo Perez?
I have not, but that would surprise me because Mr. Perez generally shows up for court. I saw him in district court last week.
All right, thank you. Bye.
Okay, this is file 21-20465-FH. People of State of Michigan versus Leopoldo Garcia Perez. We are here today for a hearing on an order to show cause for an alleged probation violation. And we are proceeding today by video conference. Courtroom is also open to the public. Ms. Underwood, do you want to place, well, I guess you haven't been appointed yet on this.
Your Honor, I don't believe I've been appointed on this show cause yet. But I do have some knowledge of Mr. Perez, and it is not usual for him not to appear in court, Your Honor. I would ask that the court perhaps set out another show cause.
Do you know Ms. Underwood? I think I saw him on the jail sheet within the last week or so. Do you know anything about that?
I'm sorry?
I think I saw Mr. Perez on the jail sheet in the last week or so. Do you know anything about that?
I do not. Maybe he's in jail.
Could you call the jail, just make sure he's not there? I would swear I saw his name.
Hi, it's Kelly and Judge. Can you let me know if Leopoldo Garcia is incarcerated? Okay, thank you very much. Bye.
Oh, you gotta go through all this stuff out of here too. Okay. I can, yeah. All these policies. That's it. Okay, there's a lot of it. I need it for. I'll take the rule.
All right, Mr. Perez does typically appear for his court hearings, sometimes gets confused, but generally always appears. So I'm going to adjourn this to June 4th at 8:15, and we'll send out another notice, and if he does not appear at that point, I would issue a warrant.
Thank you, Your Honor.
Okay, and gentlemen, of the jail, you are Mr. Castillo, correct?
Yes, sir.
Okay, so this is file 22-50122-DS, page Lee Morton, and I'm sorry, let me bring in Ms. Morton. She is logged into the Zoom session. Okay, so this is file 22-50122-DS, Page Lee Morton versus Enrique Manuel Castillo. We are here today for a hearing on a contempt of alleged contempt for failure to appear at a show cause hearing back on October 9, 2023. Mr. Castillo was arraigned on that yesterday and indicated that he was perhaps trying to hire a private attorney. Mr. Castillo, do you know where you stand with respect to that?
Yes, my attorney was actually on a Zoom call with me for my arraignment again this morning. I don't know why he wasn't informed of this one.
Okay, what was your arraignment this morning?
It was, they told me I had another court date tomorrow. And then, yeah, that's all I really remember for it. And then it was also reviewed my bond.
Do you know what the charges were in that arraignment?
I believe it was for this exact same thing.
That it would not be the same thing. Give me a second. Let me see what I can figure out.
Okay. Thank you.
Okay, so yeah, you were correct, Mr. Castillo, in that it is related to the same subject matter, but technically this is a contempt that was issued for failure to appear. In the support case, it appears that you've now been charged with felony non-payment of support, which is what your arraignment and bond hearing was about this morning.
Okay.
So what typically happens in this circumstance where there's a contempt of court pending, which means that there's an allegation that you failed to obey a court order, and that court order was the support order. What typically happens when that gets charged as a felony case is that we dismiss the contempt and just allow the felony contempt or the felony non-support case to proceed. And so that is what I'm going to do in this instance. I'm going to dismiss the contempt for the failure to appear, as well as the friend of the court contempt for non-payment of support. And you still have that felony case pending, but for the time being, you don't have anything in front of me. It's just going to be the felony case that decides what happens.
Okay.
Oh, I'm sorry. This was not a felony. This was not a friend of the court that started this contempt. It was the Ms. Iddings, attorney for Ms. Morton, started this, but that would not affect how I handle this either way, since there's a felony pending. That's the more serious charge, and so I would just dismiss the contempts and let the felony case play out.
Okay. Can I ask one question for clarification?
Yeah.
So tomorrow, my court date that I have scheduled for then, I'm sorry, for Friday, that's regarding that matter, right?
Correct. That is in the felony case. You don't have any further hearings or any dates scheduled with respect to this one.
Okay. Thank you, sir.
All right. So you're all set for today. Then you can go ahead and log out.
Thank you.
And let's see, Mr. Murphy, are you ready to proceed with Ms. Allen?
Yes, Your Honor.
And I'm sorry, Ms. Underwood, who do you have left? Ms. Coley?
I'm sorry.
Who do you have left, Ms. Allen? Ms. Underwood?
Do we have anything else, Your Honor?
The only thing I have left was a pickup for Cassie Coley, and I think Mr. Murphy, you were going to handle that because you've got the underlying case, or is that?
Yep, I can handle that, Rhonda. You don't have to worry about Miss Coley.
Okay, thank you.
Let me get Ms. Allen back. There she is. Okay, this is file 25-22156-FH and 25-22155-FH, People versus Jennifer Lynn Allen. We are here today for a contempt of court in the 21-22155 case. Same thing in the other case. And I also had indicated I want to treat this as a pretrial, that the alleged contempt is for failure to appear at a pretrial. So first, let me have the attorneys place their appearance on the record, beginning with Mr. Bandetto.
Yeah, it's Bandetto for the people.
Matthew Murphy, appearing on behalf of Ms. Allen.
And Miss, you are Jennifer Lynn Allen.
Yes, Your Honor.
All right. Mr. Murphy, where do we stand with Ms. Allen's cases today?
Your Honor, from my understanding, the offer right now from the people will be for Ms. Allen to plead to possession of methamphetamine in one file, possession of analog, and retail fraud second in the second file. There's also some misdemeanors downstairs and a new one that was added, I believe, just a week ago or so. I'm not sure what an offer would encompass, what pleas on those files. So I'm asking if we could set another pretrial. Your Honor, I don't think we need much time. I just wanted to get some clarification. Miss Allen was screened for recovery court. It was my intention to have her enter into recovery court, as well as she was trying to get herself into an inpatient rehab before she was taken into custody. So I was going to ask the court if we could address bond in regards to the matter. But I'll just ask for another pretrial for these underlying, and I need to figure out in regards to those misdemeanor files as well what the offer is encompassing those.
Okay, Mr. Bandetto, anything that you would like to address?
No, Your Honor.
All right, I can, let's adjourn this then to May 21st at 8:15.
Sorry, you say that May 21st, Your Honor?
Correct.
All right, thank you.
And Mr. Murphy, would you do that stipulation in order?
I will, Your Honor.
All right, and what is it you'd like to say with respect to bond?
Your Honor, Miss Allen, she's asking the court to consider, first of all, I was asking the court to consider allowing her to be released to an inpatient treatment facility if the court wasn't inclined to allow her to be released on a PR bond. It was her intent to enter into an inpatient treatment. Unfortunately, she is suffering from an addiction, which causes fear and obviously concern about going to inpatients in regards to, I guess I haven't been addicted myself, but I understand the fear that people face in regards to basically dropping off their use. Miss Allen, she was picked up. I'm not going to lie to the court. She obviously didn't turn herself in. She did have a failure to appear, but she had spoken to, I believe, the police shortly before. She had a subpoena. She had spoken to, I believe, Officer Robinson. She had said from Adrian Police Department. And this is one of the reasons why she was asking the court to consider allowing her to be released on a PR bond. It is her intention to go. I have spoken to Mr. Coast. Again, it is her intention to go to rehab. She was intending to go there later today if the court was inclined to do a PR bond. Her concern is that she has a home where she was arrested at. There was other individuals at the home. My understanding was a search warrant was served. There's other individuals that are now living at Miss Allen's home. She has things she would like to take care of and get clarified, bills paid, things like that before she was to go off to an inpatient, and also to make sure and ensure that people aren't taking advantage of her home while she's gone. So that she was asking the court to consider a PR bond. Again, she fully acknowledges that she failed to appear. She understands failing to appear moving forward makes compounds the issue even worse. Obviously, she'll abide by any drug testing conditions. Again, it's her intent to enter into inpatient. I believe she said she can go, again, there's the detoxes that are 5 days that are pretty much you walk in. And she had already been talking to a place, so it is her intent to go, just walk into the detox, which is a 5-day, and then go into the inpatient, the actual treatment part. Again, if the court is not inclined, or is not willing to do a PR bond, I'd ask the court to consider allowing on her bond a release to an inpatient. I've already reached out to Mr. Coast, and I do believe that we'll try to get her in a bed here shortly. Like I said before, I think recovery court is the path this is taking, and I think that's appropriate for Miss Allen to get into treatment as soon as possible. Thank you, Your Honor.
Mr. Van
Your Honor, I have no objection if the court were to allow her to be released to an inpatient facility with the understanding that she must successfully complete it. But I would object to any other modification of bond. Ms. Allen has already failed to appear in this file alone. I think there's some serious concerns that if she were released, she would not appear again. So that would be our request, Your Honor.
All right, so what I would be willing to do, I think that a GPS tether would adequately address my concern about a future failure to appear. So I will allow a PR bond with GPS tether. I will also require 2 times per week random drug testing with through Mr. Coast. So Ms. Allen, when you're released, you need to come directly over to the courthouse and see Mr. Coast and set up your drug testing requirements. And you also need to absolutely comply with those requirements because I'm not going to look the other way on any violation of your drug testing requirements. So if you miss a test, if you test positive, you're gonna be back where you are because I've got to do what I need to do to best maximize the possibility that you're not gonna use again. And those are the tools I have available to me. So I will make those modifications to the bond at this point.
Thank you, Your Honor.
Thank you, Your Honor, so much.
Your Honor, that pretrial was May 28th, correct?
Yes.
21st.
Oh, I'm sorry,
21st?
21st. Yeah, 21st.
21st. Okay.
Thank you, Judge.
Okay, thank you.
And I
So
think
Ms. Allen, you can let the officer with you know that you're done with court for today.
that's all you need me for, Judge?
Yes, Mr. Baynett, we're all set with you.
Okay. Have a good day. Thanks.
Okay. And Ms. Allen, you can let the officer with you know that you're finished with court.
Okay, thank you so much, Your Honor.
Thank you, Miss Allen.
Thank you.
For Cassie.
Judge Osmond, could we have Cassie call you from Judge, please? For Judge Olsaber? All right, thank you. Bye. I'm assuming that was on. Okay.
Oh, the one that I handed you on the bus is also exempt. This, pros and cons, pros and cons. Hey, Andy, how are you? Great. You should go talk about how it is. And you said she's great after she got to tell Miss Underwood how it is this morning. Huh? Maybe. Huh? Push the door. They're just waiting.
Who am I, who is this?
All right, this is file 25-22120-FH, People of State of Michigan versus Cassie Lynn Coley. We're here today for an arraignment on a bench warrant. Miss, you are Cassie Lynn Coley.
Yes, Your Honor.
Ms. Coley, you're before the court today on a bench warrant that alleges that you failed to appear at a pretrial conference on April 23rd, 2025 at 8:15 a.m. Do you understand that that is the allegation against you?
Yes, Your Honor.
And the maximum possible penalty for a contempt of court is up to 93 days in jail or $7,500 in fines. Do you understand that?
Yes, Your Honor.
You do have the right to be represented by an attorney here today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
Yes, Your Honor.
And Mr. Murphy already represents you on the underlying case. Would you like him to represent you on this as well?
Yes, Your Honor.
All right, Mr. Murphy, you need to speak to Ms. Coley.
If I could, please, Your Honor. Thank you.
1 second. Okay, we have Mr. Murphy and Ms. Coley back from the breakout session. Mr. Murphy, do you know how Ms. Coley wants to proceed today?
Your Honor, could we just enter a not guilty plea on the contempt, schedule a pretrial for the underlying and the contempt for whatever fits the court schedule best? And then Ms. Coley is asking if the court's willing to address bond now or not.
Okay, so we'll set it for May 21st at 8:15 a.m. And what is it you would like to say about bond?
Your Honor, Ms. Coley, she is fairly sick right now. I'm hoping that she got some medication. She has been sick for some time, a few weeks, she said. I think that the missed court date was a mistake. I don't think she was trying to flee the jurisdiction, trying to flee the state or flee the court's authority or jurisdiction. We're asking the court to consider a PR bond. I understand that this case, it was a bit of time down in district court, but I think that it was a bit of time before they even let Ms. Coley know she had a charge against her. I do think that, with this, she's not going to flee moving forward, Your Honor. We are talking about retail frauds, and quite frankly, discussing the matters with Ms. Coley, we have talked about resolving them. And so she understands that failing to appear ultimately delays the resolution of the cases. So she is asking the court to consider a PR bond.
R2, please.
Okay, looking at the file, Ms. Coley appears to have had 2 failures to appear while this case was in district court, and a failure to appear now here in circuit court. So I am not comfortable at this point with a PR bond. I don't think that would adequately assure that Ms. Coley would appear at future court hearings. She just doesn't have a record that would support that. What I will do is give her an opportunity at the GPS tether. So I will modify the bond so it is a PR bond with the requirement that she have a GPS tether in place.
Yes, Your Honor. Thank you.
All right. So Ms. Coley, you can let the officer that's with you know that you are done with court for today.
Okay, thank you, Your Honor.
Thank you, Ms. Coley. You have a good day, okay?
You too, Mr. Murphy. Thank you.
Thank you, Your Honor. You have a good rest of your morning, all 8 minutes of it.